Hello.
Hello, I'm discovering all of the limitations that scientists always tell us about cloning. Oh my goodness gracious.
So, how are things otherwise?
Otherwise, Ducky, and I'm just completely thrilled to be doing this together with you today.
Yeah, me too. As usual, always like working with you guys. So, hold on a second. I'm just closing all of my windows.
Yeah, that helps.
Uh, or I forget when we do it together. Do you have the slides and I tell
I'm
you?
going to drive if
Slides?
that's all right.
Yeah, that's fine. Then I
Perfect.
closed my slides that I had up. Uh, so Michael resigned last
Michael
week.
resigned?
Yeah, and
Oh,
uh, I am like absolutely pulling my hair out trying to figure out what to do now.
oh
Um,
my goodness.
yeah, he's like he's going in house. He's not going to another firm. He's just decided that firm life isn't for him, which is that's fair. Um,
Right.
but leaving me pretty high and dry, alone in the group, and trying to hire a senior person.
I saw your shout out.
Yeah.
Yeah. Oh, Heather, hello. Maria, are you going to be on camera or not on camera?
No, my camera on my home computer doesn't work,
Oh,
unfortunately.
right. Okay. Heather is our moderator. She's supporting us. Heather's in Arizona. Heather Herbine, meet Maria Panichelli.
Hey, Heather.
Hi, I'm talking on mute.
And welcome. You are 2 minutes to the top of the hour on federal subcontracting success. I'm Judy Bratt, CEO of Summit Insight. Welcome. We're so glad you're here. Uh, People are logging on from all across the country right now. We do a couple of things every time, and that includes starting right at the top of the hour. So if I'm meeting you for the first time, welcome. If you're here for the first time, drop a number 1 in the chat. We're going to have a number of things we're going to be doing in the chat as we go along. And so if I'm meeting you here for the first time, welcome, and just drop a number 1 in the chat so we can make you particularly welcome. Christina, hi. John, hello. So glad you're with us. I see I've got some old friends, well, longtime friends. Billy, you're never old. Billy, welcome back. We're so glad you're here. Shadrad, hello, hello. We're so glad you're going to be joining us. We've got 1 minute to the top of the hour, and we're going to get started. We've got some of the most powerful issues that stand between where you may be and the success that you want. So, oh, hello, hello, is it Derry? Yeah, DK Howe. If you, for whatever reason, want to drop some contact information in the chat so people can know who else is here, go right ahead. If your name is not Leah Edwards, could you please change your name so that we know who you are? We've got a couple of registration weirdnesses. We've got less than 60 seconds to the top of the hour, and we're going to get started. And so counting them down. Again, if you're here for the first time, drop a number 1 in the chat. If this is your first webinar with us, I'm especially thrilled to meet you. So drop a little bit about yourself in the chat. Shadrad, thank you so much for saying hi. And it's time to get started. So let's do that. Teresa, hello. I'm Judy Bratt, CEO of Summit Insight. And for the last 33 years, I have been bringing the best of what I learned to the government contracting arena. Bear with me while I do the hardest thing that I do, and that is to stop for a minute and tell you what it is that we do. At Summit Insight, we're a professional consulting firm, and we work with established business owners that are looking to win the work they want with the federal buyers they are meant to serve. That is our profession. This webinar series is one of the resources that I share as an active service in the government contracting community and as a way to launch that journey of relationship between you and me. So we have the chance to get to know each other, figure out who needs to connect between you and me and other people that we know. That art of federal human connection is at the core of our work. We bring together the research, the process, and the data and light that up with that lightning bolt of relationships that brings the growth that you're looking for your company in the federal arena. All right, that was the hard part. When we close out, I'm going to have resources for you, and I'm going to have a list of about a half a dozen things that if these things are true, we might need to have a productive conversation. So with all of that, here's what we're going to cover today. You're going to understand what flow down clauses are, why they're important, and how to incorporate them when you are considering subcontracting in the federal arena. You're going to identify the most important issues that need to be addressed in a federal contract. You're going to learn how to address one of the most common sources of conflict regarding disputes. And you're going to pick up some tips on the best way to structure disputes clauses. It is my complete pleasure to introduce our speaker. But before we do that, we've got a couple of people who are still logging on. So Heather, would you launch a poll so we can get a sense of who's in the room where it happens, the room where it happens? The reason why I'm launching the poll is to give you a sense of, hey, who's in a situation similar to mine? What's going on for the people who are in the room? So Heather?
I'm hopping on it. Give me one
All
moment
right.
to get that in.
And in the meantime, if you've got questions about subcontracting that you want to be really sure that we answer, drop them in the chat now. If you've got a burning question about subcontracting, you want to make sure we got to it, put those in the chat. And that will mean that we're going to do our best to bring answers to your questions as we go along, if they're in the flow. You deserve to get those answers in the right time. Okay, so we're bringing up the poll now. Again, Darla is looking for difference between subcontracting and joint venture. Awesome. Brian's here from Arizona from Qual LED Lighting. Excellent. Again, drop your questions in. We're going to bring them across to our speaker as we go along. We're going to have resources for you and links where you can grab those resources at the end. All right. I'm going to proceed, and Heather's going to light up the poll, and you'll see that as we go. And so I'm going to proceed with content because I want to respect your time and make sure we get this done. All right. So you're going to commit to action before the end of this hour. So get out your notebook, get that thing where you write down notes, and I'm going to ask you in less than an hour's time, what one action are you going to commit to as a result of being here? It's going to take you further to your federal goals, because that's part of my goal, is to make sure you're getting to your goals. Okay. With that, it is my pleasure to introduce one of the top national experts in federal contracting and all aspects of the legal side of procurement, Maria Panichelli. Maria and I met many years ago through, I think, the National Veteran Small Business Coalition. And it's hard to say exactly where one met Maria, because she is one of the most generous people nationwide in the federal contracting arena and makes hundreds of presentations to folks to help support you on your journey. So with that, Maria is partner and chair of the government contracting group at Obermeyer, Redmond, Maxwell, and Hippel, who have offices both in Philadelphia and in Washington, D.C. Maria, you also love to travel. So I can't imagine how frustrating pandemic has been for you. How many trips have you put off that you've got in the wings and you're waiting to reschedule?
Unfortunately, there were about 4 that were scheduled for 2020, and then several that I was looking at for 2021. But can't really complain. I got refunds, and I didn't get trapped overseas, which would have been a possibility. So,
Yikes!
Yeah.
Well, I'm glad you're with us and not trapped somewhere overseas. That's good. And so welcome. We're so glad you're here. Again, people can find you on LinkedIn. We're going to share your contact information again at the end, but let's get started. Talk us through what we're going to cover, and then let's do it.
Sure. And thanks for the wonderful introduction, Judy. As Judy said, my name is Maria Panichelli. I'm the chair of the government contract group at Obermeyer. And just to clarify, we don't have a separate office in DC, but obviously by the nature of my field, I'm down there all the time. One of the major practice areas that I help clients with is this subcontracting. We do a lot of bid protest work. We do REA and claims work. We do small business procurement work. And we do, work in this arena, performance and compliance counseling and subcontracting. Subcontracting can be one of the most important make or break type of issues that a contractor can face. Sometimes contractors, especially in the federal arena, don't realize how important this can be, which is why Judy and I thought it was a good topic for today. So we're going to
And it's
start.
because it's February, we're coming still to the end of Valentine's month. So everything to do with connections and people doing things together, this is also what part of what inspired us. And so, and our poll is open as well. So please let us know a little bit about you. So Maria, are we ready?
Yeah, so today we're going to talk about, the approach that you should take overall. We're going to talk about flow down clauses. We're going to talk about pass through claims, and then we're going to talk about claims between primes and subs. So I think we can move on to the next slide. So in terms of the approach, I take a little bit of a different view, I think, than some lawyers out there. I think, before you get into the legal and the technical, it's important to think about the human interaction piece, right? And I think the theme with subcontracting, like with any interpersonal relationship, is that you've got to develop and you've got to demonstrate certain kinds of behavior. I think you need to make sure you're showing an integrity and a willingness to work. In other words, not, no one partner wants to feel like they're pulling all the weight. And you want to demonstrate an opportunity or an ability, rather, to work together, to cooperate and to resolve conflicts and to have it be more about cooperative effort as opposed to, conflict and pointing fingers. The next three kind of all go together: communication, honesty, transparency. You should be keeping the lines of communication open. You should always be honest. And there shouldn't be, a hiding the ball mentality or a mentality of, oh, well, we're too embarrassed to share this with our partner, or we don't want to, let them know that we're having issues here or there. And we're going to see as we move forward with some of the stuff we talk about today, how important communication can be in between subs and primes, because of the communication responsibilities and requirements that the primes have to be communicating things with the government, both in terms of just, doing a good job, but also in terms of preserving the primes' rights, and through that, the subs' rights to get additional money or get additional days if something goes wrong. And then finally, like any other, interpersonal relationship, empathy and understanding. And I say that not just from a, kumbaya, everybody holding hands point of view, but as you're going to see as we move forward in the presentation today, it's important to understand when you're negotiating a subcontract where the other side is coming from, because even from a selfish point of view, that's going to give you, a better idea of where you've got wiggle room to negotiate and where you do not have wiggle room to negotiate. So next slide, please. All right, so first we are going to talk about flow down clauses and risk shifting provisions. Next slide. What are flow down clauses? You've probably heard the term, obviously it was in the agenda run through and the blurb for this webinar, but in the simplest sense, flow down clauses are FAR clauses that are included in a contractor's prime contract, which the prime contractor then flows down to their subcontractors. And by that, I mean, there's variations on this theme, but pretty much cuts and pastes from their prime contract and tweaks it and puts it into the subcontract. We're going to talk about in just a minute that sometimes this is mandatory and sometimes it's just recommended, but that is what a flow down clause is. It's just a fancy name for taking something that you've got in your upstream contract and putting it into the downstream contract with your subs.
And Maria, I think someone had a question about, I think, whether or not you can incorporate by reference.
So I'm going to get to that in
okay, good. I will just hold that for later.
Thanks. So next slide, please. The other thing, in addition to flow down clauses, in the strict sense, what I was just talking about in terms of actually taking the text and the words and, either verbatim or tweaking it, is if you're a prime contractor, you're also going to want to think about clauses that you don't necessarily need to flow down, but that, there's other risks that you might run by delegating certain work to a subcontractor that you need to be thinking about and you need to be including in the subcontract. And we're going to give some examples of those as we go forward. So, from a starting point, when you're a prime, you're approaching this with, okay, what are my flow down clauses that I either must or should include? And what are things that I don't necessarily need to flow down, but issues that I need to account for, risks that I need to either shift or share with my subcontractors. Next slide, please. So none of these concepts that we're talking about today are limited or exclusive to the federal government contracting realm. but they can be more important in the federal government contracting industry just because of the differences between a federal government contract and a commercial contract, or even sometimes a local or state or municipal government contract. As many of you probably out there know, the federal government contracts are governed by a complex set of laws, most notably the FAR, the Federal Acquisition Regulation, as well as agency supplemental regulations, FICA, the Tucker Act, Small Business Act, the Administrative Procedures Act, etc. So they are subject to a completely different set of dispute resolution procedures. You go to different adjudicatory forums. You're not going to normal state court or a U.S. district court when you're dealing with disputes against the government. And because of the interaction, obviously disputes with the prime and the sub can sometimes involve the owner. And because the owner here is the federal government, and because the owner is the federal government, and that means that there's all these different sets of rules, that kind of trickles down through the whole process. It means that everything needs to be addressed in a little bit of a unique way. Next slide. The biggest reason for this is that the federal government does not bend or negotiate. For those of you who are prime contractors, unless you're in the OTA realm, which is rare.
What's
you're not
OTA?
Other transactional authority or other transactional. Unless you're in that realm, which is usually reserved for research and development, you're dealing with contracts where the terms are set and you compete for a contract of which the terms are set. You're not going back and forth, crossing clauses out and saying, nah, thanks, Mr. VA, or thanks, Mr. GSA, I'm not going to do that part. You've got to do what the government told you to do, which means that, if you're a prime, you have very little wiggle room in terms of, what the obligations are under your contract. And therefore you need to be careful in terms of the power you're giving your sub over you to make you breach those obligations to the government. From a subcontractor's point of view, again, going back to the empathy and understanding piece that I talked about several slides ago, it's important to understand where your prime contractor has wiggle room and why perhaps on certain things they don't have wiggle room. And again, that's not necessarily saying that you just, accept everything that they try to flow down to you or accept every risk they try to shift to you, but you can at least understand why they are trying to shift certain things. And then that's going to give you some ability to say, okay, look, I understand you're trying to protect yourself against this risk, but we can do it this way, and that is better for me, but it still protects you. That's where the empathy and understanding in particular, come into play. So like I said, prime contractors can be reluctant to negotiate with subs because of this lack of wiggle room, unless the subcontractor can really educate themselves as to some of the issues the prime is dealing with, as to some of the concerns the prime might have, as to kind of the requirements relating to flow downs and to risk shifting. And if the sub understands that, it's going to put them in a much better place to negotiate, which is why we now want to move into talking about how to understand each other and, what to think on each of those issues. So next slide, please. So, on the point of trying to understand the other party, the prime is most likely thinking, hey, I've got a relationship with the federal government. This is a big deal. I don't have a lot of wiggle room. There's a complex set of rules that's governing my performance and how I can deal with issues that come up. I can't have my subcontractor put me in a position that, risks a default, of my own contract with the federal government. I can't afford to be stuck in the middle where if something goes wrong, I'm trying to file an REA or a claim against the government, but my sub is nipping at my heels, trying to get the money back from me. We need
What's an REA, Maria?
request for equitable adjustment. It's when you
Oh.
go up against the government asking for them to adjust the contract, either
Uh-huh.
in terms of days or dollars for issues that have come up during performance.
Like pandemic.
Exactly. So you don't want to be in a situation where you're trying to go after the government as a prime, and say, hey, look, I need additional days or I need additional dollars on my contract. And your subcontractor, rather than cooperating with you and, waiting for the government to respond, is filing a suit against you, and, trying to get that money out of you while you're still seeking it from the federal government. The other major concern from a prime's point of view is that, a subcontractor's alleged fraud or False Claims Act violation, if they're making inaccurate claims about the money that they were owed, or, if they're doing anything inaccurate in terms of the Service Contract Act or other issues like that, the prime doesn't want to be responsible for the subcontractor's malfeasance. Now, on the other hand, subcontractors, and this isn't, this is a little bit of an overgeneralization, but subcontractors are often smaller companies. Especially if you're dealing with big government contracts, unless it's a set aside contract in which the positions might be reversed. But the sub might be thinking, hey, look, I'm a smaller contractor. I'm less familiar with the FAR. I've done less federal contracts. I really need to make sure I'm protecting myself. I need to understand what my obligations are under my subcontract. And I can't wait. The big guy, the prime, might be able to wait 7 months, 8 months, 2 years while they litigate against the government and try to get some money or days added to this contract. I am small and I can't self-finance that. So those are the things, the prime need to understand what the sub's thinking, and the sub needs to understand what the prime is thinking. Next slide, please. So then when you get into actually, what goes into the contract and what do I include, I'm going to be approaching this from mostly a prime contractor's point of view, especially in the beginning, and then we're going to do some shifting over to a subcontractor's point of view. But again, one of the things I've probably been harping on already is that it's really important to understand where your partner is coming from, right? It's really important to listen and hear and see what their position is, and therefore don't tune out if you're a sub and you're listening to these tips for primes. And, when we get to the part about subcontractors' point of view, don't tune out if you're mostly a prime. This is what gives you the tools you need to understand where the other side is coming from and to have a worthwhile relationship where you assuage both sides' fears and account for, what both sides want. So, all right, from a prime contractor's point of view, the first question you're going to ask yourself is, what do I flow down and what do I include? We talked about flow down clauses. The first thing you're going to look at is mandatory flow down clauses. And this is a no-brainer. You're going to look at the clauses that are in your contract. And for those of you who are familiar with federal government contracts, you'll know you probably have pages and pages of clauses that are incorporated in full text. And then you probably have a couple pages or at least a page of clauses that are incorporated by reference, right? Just by the title of the contract. Now, or I'm sorry, by the title of the clause, rather, I should say. You're going to have to go through, or you're going to have to work with a lawyer to go through. And there are certain shortcuts on certain parts of this, but some of it is just literally going through every clause. And the FAR itself is going to tell you whether it's a mandatory flow down. It's going to say that, if this is in your contract, you have an obligation to flow it down to your subcontractor. So if it's mandatory, then flow it down. Please do not make a mistake that I see a lot of people make, which is confusing mandatory and automatic. Mandatory means you have an affirmative obligation to do it. It doesn't mean that even if you forget, it's already done and everyone's just going to assume you did it. So mandatory means you need to take a step to do something, not that it's automatically, that box is checked. So on top of the mandatory flow down clauses, there are suggested clauses. Maybe the FAR doesn't tell you absolutely need to flow down the clause, but there are reasons in terms of risk shifting. Next slide,
Maria,
please.
you talked about automatic. I'm not seeing this on the side. Are you going to be talking about the difference between a mandatory, which that's been clear, the FAR says you have to do it. What's an automatic flow down, and where do you know where those are?
There isn't an automatic flow down. And if you go to the next slide, you'll
okay.
see. Yeah. So as I said, the mandatory flow downs are, they're going to be in the FAR. It's going to make it clear if it's mandatory that you need to flow it down. There are no such things as automatic flow downs. Your subcontract is going to be governed by what you put in it. So you need to make sure to put the things in it that need to be there. There's no automatic cut and paste. For those of you who are familiar with the concept of the Christian doctrine.
Someone just asked about that. I've never heard of that. What is that?
The Christian doctrine in prime contracts is the idea that even if the government, maybe made a cut and paste error or forgot to put a clause in, that there are certain clauses, typically the ones that are considered so fundamental or seminal to government contracting, that even if the government forgot to put them in the prime contract, they're going to be read in there. The court's going to assume that they were in there anyway. Those are things like, the changes clause or the disputes clause. You kind of have to go through the case law and see where the courts have said in specific cases, all right, this clause is so fundamental that we're going to read it in there, even if it wasn't put in there. There is no equivalent of that with subcontracting. Your subcontract is governed by the subcontract document. So Don't mess up and think that things are automatically in there. If they're mandatory, you need to flow them down. Next slide.
Yeah, and this takes me to the idea that one of the things that people ask often is, hey, is there someplace on the internet where I can find a template for a subcontract? And the answer is, you're hearing why the answer is absolutely not, because there's only one you, and there's only one relationship you have in that instance with that partner, with that contract, with that agency, with that content. So this is subcontracting agreements are not a do-it-yourself exercise. I
No.
want to put down a marker and say, there's a reason why we get dental checkups. There's a reason why we get an annual physical, because you want to get professional advice and know ahead of time how to stay out of trouble. Why it is that we don't pay for basically the equivalent of upfront legal services more often is completely beyond me, because it costs a lot less to go and get things taken care of up front than it does when you've done do it yourself and you got messed up plumbing. All right, moving on.
So let's move on and we can go to the next slide. This is just a title slide and we kind of already started to talk about it. In terms of what additional considerations should you be thinking about as a prime, you've gone through your contract, you've figured out your mandatory flow down clauses. Now you've got to think, okay, what else do I want in there? I'm not required to have it in there, but what's a best practice to protect myself? And answering this again starts with, it's not a one size fits all answer. It's not a boilerplate or, template agreement type answer. You have to think thematically and you've got to think purposefully. And you got to think, well, what's the purpose? What am I trying to do in this subcontract? Sure, you're trying to get your subcontractor to perform a portion of the work. That's, on the most basic level. But you are, as we talked about before, as the prime, ultimately responsible for the completion of the contract in a successful way, right? That means you are responsible for the performance of your subcontractors. So anything they could do that would jeopardize your ability to complete the contract from the government's point of view is something that you want to guard against and, hopefully put provisions in there to avoid. But also, to the extent that it's unavoidable, you want to have provisions in there that protect you and say, well, it's going to be the subcontractor's point of view or the subcontractor's responsibility. The other thing that you really need to guard against, and this is one of the areas where it is more important in the federal government contracting sphere than I think it is in commercial or local municipality type government contracts, is that you've got to figure out issues regarding notice failures and delay. We're going to see some examples in just a little bit, but when you're talking about a lot of the things that can go wrong on a federal government contract, the prime contractor is going to be able to go back later and say, hey, I want additional days, I want additional dollars, this contract needs to be adjusted, if they give proper notice. If they do not give proper notice, a lot of their rights are going to be restricted. So one of the things that's really important is to, make sure that the subcontractors understand those obligations and that you as a prime are putting things in your subcontract to make sure that you're getting the appropriate notice so that you can turn around and deliver the appropriate notice to the federal government. Federal government does not mess around. They don't like finger pointing. They don't like blame. If it's your subcontractor's fault from the federal government's point of view, that makes it your fault. They're under your umbrella. So you don't want to be in a position where where your subcontractor can force a default, cause a notice failure, cause a delay, etc. You need to be vigilant. Next slide, please. So I want to give you an example so you can kind of see one of the things that I'm talking about, where this isn't necessarily a mandatory flow down clause, but it's a place where contractors can get caught in the middle. Prime contractors can get caught in the middle. There's a terminations for convenience clause in generally every government contract. That's not a termination for default. It's not a situation where the government says the prime contractor did something wrong and we're going to terminate them and go after them for fees, et cetera, et cetera. It's not a black mark. It just says that the government said, actually, we don't need this anymore. So we're going to terminate this for convenience. It's not in the best interest of the government to continue on this route. Next slide, please. So in this example, that's exactly what happened. No mark against the prime contractor. The prime contractor didn't do anything wrong, but the government said, we don't need this anymore. The requirement that we originally had solicited for, turns out we don't need it. So we're going to cancel this contract for convenience. We're going to terminate it for convenience. The prime contractor had not, unfortunately, put a termination for convenience clause in their subcontract. So nothing in the subcontract addressed or gave the government or gave the prime contractor the right to terminate their sub for convenience. They were only allowed to terminate them for default. Well, there was no default. There was nothing that had gone wrong. The government wasn't blaming anyone, no black mark, etc. So for the prime to turn around and try to terminate the sub's contract without giving them any money, the sub was like, sure, go ahead. I'll sue you for breach of contract. So the sub was basically saying, that's great. I'm sorry that you no longer have money coming in from the government, but you didn't give yourself a right to terminate me for convenience. Sorry that happened to you, but you still owe me money. Now, we were able to settle this and, find a solution that worked out for everyone. But obviously, you don't want to have to hire someone like me. Like Judy said, later in the process, it's always better to be proactive and set yourself up to not have a problem later. So for example, this is just one example, termination for convenience clause is a very important thing to flow down, even though it's not necessarily a mandatory flow down clause. It's a place where you could get stuck, where the government can do something to you and you can't do the same thing to your government, or I'm sorry, to your subcontractor rather, and that is a bad place to be. Next slide, please. So the lessons coming out of this. As a prime, you always want to avoid battling on two fronts. You never want to be in a situation where, you and your subcontractor are not on the same page and you're trying to go after the government for something that was the government's responsibility. You never want to be stuck in the middle where the government terminated you and you can't terminate your sub. You never want to be stuck in the middle where both the government and your sub are pointing fingers at you and saying you did this wrong and you're fighting two fights at the same time. So to avoid that, you want to carefully study your prime contract and work out all the possible scenarios, any contingencies, any things that you think could go wrong. Make sure that you have, your rights and obligations to the government, which are governed by your prime contract. You want them to be mirrored in the subcontract that you put together with your subcontractor. A lot of the boilerplate ones that you find online aren't going to cover that. So prime contractors, make sure that you have the subcontractors obligated to you to the same extent that you are obligated to the government, and to the extent that maybe you need to leave yourself some wiggle room. For example, if you need to give the government notice within 14 days, you probably don't want to have your subcontractor giving you notice within 14 days, right? Make them give you notice within 10 days so that you then have the additional 4 to get your people on it, to turn around, to give the notice. You need to think critically and not just cut and paste things, and be thinking about the purpose behind what you're trying to do in your subcontract. You want to protect yourself. If you have an obligation to the government that implicates the sub, if there's a way that the subcontractor could cause a default or a notice failure, you're going to want to either, flow that down or otherwise account for it in your subcontract. Anytime the subcontractor could impact your performance, you need to account for it. And you want to make sure, like I said, that the subcontractor is accountable to you to the same extent you are accountable to the government. Next slide, please. Okay, I think I kind of already went over that with some of the comments with Judy earlier, but again, just make sure that the obligations that you've got to the government are mirrored in your subcontract. Now, with that, let's flip over to what the subcontractors need to be thinking. So next slide, please. Same way that you need to be thinking as a prime, what the purpose of your subcontract is. You need to be thinking as a sub how to protect yourself, and where you're going to have wiggle room and where you are not going to have wiggle room. And I think the biggest thing that you need to understand is your obligations, right? We see a lot of subcontractors, especially if they are less informed and less experienced, they don't have a clear idea of some of the obligations that are in the prime contract under the FAR. So what we see a lot of times is that primes are doing these non-specific catch-all flow down clauses. Something like, there's two ways of doing it. Sometimes you'll see, and this kind of goes to the question that I said I would be talking about later. Sometimes you'll see people incorporate by reference in their subcontract, just say, we've incorporated all the FAR clauses in our prime contract by reference. Or they'll just give a list of all the FAR clauses that are incorporated by reference. Or they'll just say, the subcontractor is bound to the prime to the same extent the prime is bound to the government. Now, at first blush, that seems consistent with the advice I was just giving to the primes, right? Yes and no. So that's your broad brushstroke goal. That's not the exact language you want in your contract. And the reason for that is if you just give a vague catch-all flow-down clause, and if you as a subcontractor just agree to a vague catch-all flow-down clause, you don't know what you just agreed to. Do you have a copy of the prime contract? Have you looked at all of the obligations that the prime has to the government? Because you just said, yeah, my relationship with the prime is the same as the prime's relationship with the government. Okay, but do you know what the prime's relationship with the government entails? Do you know the obligations and requirements that they have to meet? Because you just agreed to meet them. If you don't know specifically what the obligations are, you don't know specifically what you just agreed to. That means you're risking default, you're risking notice failures, that risks all the things that you're hoping to avoid. Next slide, please. So, quick example of where we've seen this happen. We had a case where we were not involved in the subcontracting, as Judy warned you about. Unfortunately, the prime had gone and used a boilerplate not tailored for government contracting, let alone for their area, let alone for their industry, let alone for this type of project. And they used a vague catch-all flow-down clause. The sub was inexperienced, didn't know much about government contracting, had no idea about FAR notice requirements, especially dealing with differing site conditions and defective specifications and changes to the contract. So what happened is that there were some issues that came up during the project, and the subcontractor didn't give proper notice to the prime. They were a little scared. They didn't want to seem inexperienced. They thought, I'll just handle this on my own, and if it becomes a problem, if we can't solve it, I'll go to the prime later. And unfortunately, because of that, they weren't able to solve the problem. The problem continued and was exacerbated. And ultimately, when the prime was brought into the loop, the prime said, "All right, well, we're going to have to go and file an REA, request for equitable adjustment, or a claim against the government, and say, hey, this is something that the government did wrong. It affected me. It affected my subcontractor, and we're both entitled to money and to an extension of the contract." But the government turned around and said, right, but in order for you to be entitled to an adjustment of the contract, you had to give appropriate notice. And the prime said, but I couldn't give appropriate notice because my sub didn't give me notice. Well, obviously the government was like, that's not our problem. So again, this is a situation we were able to ultimately get around, but it cost more than the client wanted to in legal fees. It took longer than the government wanted to, or I'm sorry, than the client wanted to get their money back. So poor drafting hurt in that situation, both the prime and the sub. So next slide, please. The lessons here are, both for subs and for primes. Again, going back to the understanding each other and understanding that your futures are kind of tied together when you're dealing with a subcontract issue. From the primes, or the subs point of view, you need to make sure you understand your obligations and responsibilities in specific terms. So don't agree to a catch-all flow-down clause if you don't know what that means. If they are referencing the prime contract documents, get them. If they say, I'm sorry, those documents are confidential, or those documents are protected, or you don't have security clearance, then say, okay, well, then we need to rework the contract to not reference things that I can't read. Take the specific language out and give me specifics about my obligations. And the last piece for subcontractors' point of view is, the same way that the prime is pushing for your obligations to them to mirror their obligations to the government, you need to push that, okay, fine, but if fulfilling those obligations gets you something from the government, fulfilling those obligations should get me something from you. So, to the extent that you're trying to have stuff trickle upstream, you've got to make sure that the same way it trickles downstream. But again, going back to the everyone needs to understand both sides of the argument here, this isn't just a lesson for subs. Sometimes prime contractors are like, I think I'm, pulling one over on my subcontractor because I wasn't very specific in my subcontract, and therefore I'll have the upper hand if something goes wrong. I'll be able to say, like, I didn't show my cards. Yeah, that's not a good plan. Because as you can see in this example, the poor drafting and the fact that the subcontractor was in the dark not only caused problems for the sub, but it caused problems for the prime because the prime wasn't able to give the appropriate notice. And that ultimately impacted the prime's ability to seek an adjustment of the contract in the way that they needed to.
Maria, how often do you see subcontractors signing things that they don't read?
Too often. I mean, once they've worked with us once and once they've gone through one of these issues, not as often anymore, but an alarming amount of subcontractors sign things and think that vague obligations are fine.
Now, how, and a different question, when big giant prime hands down a subcontracting agreement, which may or may not have all kinds of incorporations by reference and all that, what power or obligation or advice do you have for a subcontractor to not only read it and say, nah, I don't want this? And what kind of negotiating power does a subcontractor have when big giant prime hands you a thing and says, here you go?
I mean, I think the key is if you don't have that leverage and if you don't have the ability to talk to them at all, the honest answer, while it's an unpopular answer, is that, that might not be someone you want to work with. You've got to do a risk assessment, talk to an attorney and say, look, these are the risks you're running in signing something like this. If you really want to work with that prime and you really want to get your foot in the door, then that's your business choice. And sometimes, depending on who the entrepreneur is or who the CEO is, some people are less risk averse and some people are more risk averse. If you're willing to take the risks in order to start establishing a relationship with a prime and you don't have a lot of leverage or wiggle room or negotiation power, so be it. The key is just knowing what risks you face. And my fear is always that a lot of subcontractors, especially smaller businesses, don't know, what risks they're facing. They sign things saying like, what's the worst that can go wrong? And they don't realize, well, the worst that can go wrong is like, this could destroy your entire business.
So would you recommend that anybody who is subcontracting, who hasn't done it for a first time, they get handed a subcontract? Would you recommend that they have an attorney that is experienced in federal contracting review that thing before they sign it?
Yeah, I mean, I think it's very important to have an attorney review it. I think it's very important to have an attorney that specifically has knowledge of government contracting
Yes.
to review it, because someone who doesn't know, a lot of what you get into is the disputes that go all the way upstream against the owner. And that is all of those, unique government contracting laws that I talked about before. A general commercial litigator or a general transaction attorney isn't going to know how to handle those things.
So it's important if you have a pet lawyer you work with, but the lawyer that does your will or your trust or your estate or whatever it is, your general business law, if they don't have experience in federal contracting, you need to ask them the question. And if they don't, then you need to have a specialist in that. Okay.
Yeah. So next slide. When you're talking about this from the subcontractor's point of view, the primary objectives or the primary purpose that you're trying to fulfill is, know what your obligations are in specific terms, know the contractual procedures that you need to abide by, and then avoid assuming liability for compliance with clauses that are not mandatory. So next slide, please. These are just, by no stretch of the imagination, an exhaustive list, but this is a kind of a checklist of things you're going to want to go through with your lawyer when you're drafting these things. The mandatory flow down clauses, where are the notice requirements and how do I flow them down? What happens if there's a termination, for convenience so that you don't get put in that position that we just talked about? And what about for default? How can you hold the subcontractor responsible if they force a default? If you're a subcontractor, how can you make sure that you don't get responsible, get held responsible if it wasn't you that defaulted, that you were doing everything fine and it was the link in the middle, the prime, that was a problem? Along the same lines, delays, suspensions, changes, those are all things that can come up during performance. You need to make sure that you've got a dispute resolution process worked out. And then, of course, cost and pricing, what's going to happen with the option if it's exercised, labor and employment issues, ethics requirements, and other compliance concerns. Those last three that I just said, the labor and employments, the ethics and the compliance concerns, be aware that, in certain cases, it's not just the FAR clauses that you need to flow down, but in certain cases, you need to be making sure your subcontractors are complying with certain labor and employment laws, Service Contract Act, Davis-Bacon Act. You need to make sure that your subcontractors are doing certain things with regard to, affirmative action and promises in terms of non-human trafficking. So there are other compliance things that you need to make sure that are, buried in the law somewhere that need to be flowed down. And then finally, IP issues, you don't want to be sharing intellectual property across a subcontract if you don't know, or you need to protect yourself if you're going to be sharing IP information either with your prime or your sub. Make sure that there are NDAs in place and that there are, non-competes in place and things like that. Next slide, please. So we're going to be talking now about subcontractors pass-through claims, and we're running short on time, so I'm going to try to cover it fairly quickly because it kind of links up with some of the things we've already talked about. Next slide, please. General rule and why this becomes an issue is that when you're dealing with the federal government, Subcontractors do not have what's called privity of contract with the government, right? They don't have a direct contract with the government. The subcontractors have a contract with the, I think we're going backwards now. We need to go, there we go. Subcontractors don't have privity of contract with the government. They have a contract with the prime. The prime in turn has a contract with the government. So there is a general rule. It's something called sovereign immunity, where the general rule is you can't sue the United States. There is an exception to that if you have a contract with the United States. But as we just said, the only person that has that is the prime, right? So you cannot, if you are a sub, sue the government directly, even if you go through all the processes and procedures that are unique to the FAR and the Contract Disputes Act and unique to the federal government space. You can't do that on your own. You need to rely on your prime. Your prime needs to sponsor or pass through your claim. Next slide, please. So if something goes wrong on site and you and your prime agree, well, that's not the subcontractor's fault, that's not my fault, the prime's fault, that's the government's fault. There was a defective spec, or there was a delay that was caused by the government, or there was a differing site condition, or the government changed the contract while we were performing, something we've seen a lot of in these COVID times. These are things that are ruled by the Contract Disputes Act. The subcontractor needs to kind of package their claim, give it to the prime. The prime kind of puts their stamp of approval on it and then passes it through. Sometimes the prime combines that with, their own claim, depending on the factual situations involved. The prime is then the one that litigates that claim, and the sub provides support. Now, unsurprisingly, this can be a huge source of conflict between primes and subs because there's so much tension involved, right? Next slide, please. Going back to our theme of understanding your partner and kind of knowing why this is an issue, what is the prime scared of? Well, they're scared of those things that we've been talking about all along, the purpose, avoiding being stuck in the middle. They don't want a situation where they go, okay, we've agreed that the government changed the contract. It's not my fault. I'm the prime. It's not my fault. You're the sub. It's not your fault. It's the government's responsibility. They owe us both time and money. So will pass through a claim for you. What you don't want is the subcontractor saying, yeah, but that long, complicated federal contract process is taking too long. So I'll let you work that out. In the meantime, I'm going to sue you in state court and say that it's your fault. You need to draft your contract as a prime contractor to avoid that. The other thing that primes are scared of is, like I just said, they need to pass through their subcontractors' claims, right? So there is something called the False Claims Act. There are forfeiture statutes. There are fraud statutes. And if you've got a situation where the subcontractor puts something together that is perhaps a little bit suspect, the prime passes it through. The prime is the one that's on the hook for that. They just submitted a false claim to the government. If they batched it with their own claim, they just forfeited their own claim. And in addition to that whole claim being denied, they might now be actively being sued by the government or investigated or what have you. So that's another big fear that primes have, and they want to protect themselves against. Meanwhile, the subcontractor is like, that's great, guy, but I'm a little subcontractor and I can't sue the government directly. And I need to have some remedies built into my subcontract to make sure that if the government does something wrong, you have to sponsor my claim. Okay, maybe we make some requirements in terms of I need to meet these 3 criteria and I need to certify my response to you. And you have some remedies against me if I falsely certified something to you that then causes you problems with the federal government, but I need to have some, remedy. And also, if you're a subcontractor, your main concern is going to be the delay in recovery and the extent to which, you might have to wait while the prime contractor works through that long and complicated CDA process. Next slide, please. So the key is to draft your subcontract to address these concerns. And again, there's no one set way to do this. It's going to depend on the parties, how much each party is willing to compromise, how much leverage and bargaining power each party has. That's going to differ from, person to person, to company, to situation. The key is just to talk to a lawyer who understands these things enough to advise you as to the risks you're taking so that you can decide if you want to take those risks or if you want to walk away. And look, sometimes you're not going to want to walk away, and sometimes you're going to say, no, there's no way I'm risking that. I am walking away, even though, this is a great opportunity for me. The key things that you're going to want to do is have a disputes clause that outlines the cooperative nature of the relationship between the prime and the sub when they're going upstream against the government. To address the subcontractor's point of view that, or, the subcontractor's concern that they don't have any remedy, you want to say, okay, well, as long as the subcontractor does A, B, and C, the prime agrees to sponsor, and they will pass through the claim. That will also assuage the prime's concerns because you can make A, B, and C. You can make the requirements the sub has to meet, things that, try to get around that fraud issue. Like I said, have the sub certify to you what they're putting together, have the sub indemnify you for any damages it causes you if they put together something that was fraudulent. That will kind of walk a line between addressing the prime's concerns and the sub's concerns. And that's, usually a good way to try to address that and walk a middle line that works for everyone. You're also going to want to make sure you have a disputes clause that differentiates between subs between the sub and the prime, and disputes between the sub and the prime on one side and the owner on the other. You want separate disputes clause, or at least separate sections of a disputes clause that lets you see how things are handled differently. You want a disputes clause that specifically refers to the CDA remedies, the Contract Disputes Act remedies that the prime is going to need to pursue against the federal government. That's going to show that you're all on the same page and the subcontractor understands how this process works, and that their pass-through claim might take a while, and this is the process that it's going to go through, and that it demands patience. And again, from a prime contractor's point of view, you want your sub to know that, because if that's not tenable for them, you will end up with the subcontractor suing you down the road, and you'd rather avoid that now. You should know it now. From a subcontractor's point of view, that's going to allow you to plan and say, I can't wait that long, I can't run that risk, I'm going to walk away, or no, I think I can handle that risk, let's go for it. I want disputes clause that provides for penalties for fraudulent certification. That's going to go a long way to helping the prime not be nervous about passing it through. And you're going to want to address whether or not you want to have kind of a stopgap arbitration. Next slide, please. This is an example of a clause that, you can see in subcontracts. It's got boilerplate language. Arbitration clause, applicable disputes between the prime and the subcontractor that do not involve the government, and a requirement that all other disputes be passed through to the government. There are two problems with this clause, though. So if you've got something like this, this is another example, like Judy said, where if you're pulling boilerplate stuff off the internet, it doesn't always help you. The first problem is it doesn't adequately incorporate the disputes procedures from the prime contract for Miller Act purposes. If you are a construction contractor or dealing with anything in the construction context, that can be a big problem. And it doesn't provide a mechanism by which the prime and sub can decide, okay, this is a dispute against the owner, or this is a dispute against the sub or the prime. This is something that is really important to address, because you need a clause that says, here's how one is handled and here is how the other is handled. Well, who decides which of those buckets you go into, right? Which of those chutes or ladders you climb up or slide down? So those are two things that you definitely want to address. Next slide. So the summary: best practices for subcontract disputes and how to incorporate that into a subcontract that works for both parties. The disputes clause from the prime contract should be flowed down in full, verbatim from the prime contract. You should also add an additional clause that talks about the continuation of the work. A big thing in federal government contracting is that while you are arguing with the government about whether they owe you additional days or dollars, you need to keep doing the work they told you to do. If you don't do that, you risk a default. If your subcontractor does not do that, they risk you getting a default. So you need to be real clear, not only about the dispute itself, but about the subcontractor's obligations while the dispute is pending. If you're a subcontractor, that's going to be something you want to take into account. Can you afford to self-finance additional work while the government and the prime contractor are arguing about whether you and the prime contractor get additional money? If not, pay close attention to what obligations you have, sometimes called prosecution of the work, sometimes called continuation of the work. That is a very important clause because it governs what you need to do while you're in the midst of disputing, getting additional money from the government. Next slide, please. You should also, in the subcontract, set forth a method to determine if the subcontractor's claim is a claim against the government or a claim against the prime contractor. That's what I was talking about before in terms of, which chute or which ladder do you take. Subcontract should explicitly set forth which dispute resolution procedures need to be exhausted before the subcontractor can demand arbitration. Next slide, please. For every claim in excess of $100,000, you're talking about a certification that needs to be done. And for REAs where you're over the simplified acquisition threshold and it's a defense agency you're dealing with, you need to have a certification as well. So a prime contractor passing through a subcontractor's REA or claim needs to include that certification language. You should have stuff included in your agreement that says what happens if the subcontractor did something that causes you, the prime contractor, a problem in terms of certification. Subcontractors should be obligated to certify their own stuff. And maybe there could be something negotiated. Obviously the prime would want there to be some sort of monetary payment if something goes wrong. The subcontractor obviously would want to say no, that they don't want to do that. And that's just going to be another one of those, how much leverage and how much bargaining power does each side have. Next slide, please. Real quick, this is kind of outside the scope of what we're talking about today, but just so that you're aware this exists. Once you get into kind of the litigation itself, if you are a prime or a sub and you're involved in a pass-through claim, you're going to want to talk about not just operating within the confines of the subcontract. Sometimes you want to put together a separate agreement called the liquidating agreement, and that's going to govern the actual litigation practice of that pass-through claim. The reason that's important is because you can kind of split up legal fees. You can talk about who's empowered to settle, and whether or not the subcontractor wants to take a portion of the settlement, or if it's going to be distributed pro rata, etc. There's a lot of issues that need to be worked out once the litigation is in place. So keep in mind that there might be, in addition to further negotiate the terms of the litigation of the pass-through claim at a later point through a liquidating agreement. Next slide, please. We're going to finish up by talking real quickly about subcontractor versus prime contractor claims. Next slide, please. The biggest place we see these kind of ties into what we talked about before, the subcontractor's big fear about, I can't go after the government directly, so I've got to go after the prime and try to get my money that way if the prime isn't passing through my claim, or if the prime passing through my claim is taking too long. In that case, what you see the most often is that the subcontractor brings suit against the prime contractor in the appropriate U.S. district court, or possibly in the state court, depending on jurisdiction, or depending on location, or depending on what type of nature it is. They also could proceed to arbitration if it's authorized in the subcontract, which is why you need to have detailed conversations about arbitration. And then, of course, if you're in the construction industry, there's always the option to submit a claim to the prime's surety. Next slide, please. Things you're going to want to think about in terms of ADR, and by ADR, I mean alternative dispute resolution. You could put clauses in your subcontract dealing with arbitrability. You can have a mandatory mediation, depending on your factual circumstance. That's going to want to be an option you explore with your lawyer. They're going to be able to tell you whether, given your specific facts, if that's advisable or not. It's not a one-size-fits-all answer. Generally, I personally don't think it's that useful, but some people disagree with me on that. And it's something you should talk through with your attorney. And as an attorney, you should talk through with your client to see what their opinion is. Location and attorney's fees of the ADR. That can make a big difference. There's a lot of money that can be spent if you're, if you don't think to specify where ADR is, and, therefore it's in California and you've got to fly your whole team from Arkansas to California. You might want to have something, especially in the age of COVID, that remote is possible, or that, you pick a central location, or that fees are split for the ADR, etc. Finally, next slide, please. Other things that you want to address: damages for delay, pay if paid or paid when paid clauses, exhaustion of administrative remedies, and jurisdiction. These are all things that come up in terms of, just this isn't necessarily flow down. This isn't necessarily specific to the federal government context, but they're things that you want to talk about with your lawyer when discussing the prime versus sub disputes piece of your disputes clause. Next slide, please. And for those of you, finally, we've touched upon this before, but just to kind of close with a reminder, for those of you who are in the construction industry, there are no liens. If you're used to doing commercial projects or local projects, you know that you can lien property as a subcontractor or a vendor. You cannot do that on a federal government project. You can't lien against federal property, but you do have the option of going after the bond, going after the surety holder, through a Miller Act claim, and that's a whole different type of litigation that takes place in U.S. District Court. But it's something that you want to talk about with your lawyer to make sure you're leaving your options open, because a lot of times as a subcontractor, that's a really good piece of leverage to use. So even if the CDA litigation is taking a really long time, even if you can't sue the guy directly, you might want to send a letter to their surety. It might shake some things loose, and especially if you're just looking for a settlement payment real quick to keep things moving, that can be a great thing. And with that, we can move on to questions. I will turn it back over to Judy, and I know if we have questions we don't get to today or questions that come up later, you've got my contact information a couple slides from now too. You can always feel free to reach out directly to me.
Absolutely. And Maria, thank you so much. Here's Maria's contact information. Heather, would you drop Maria's contact information into the chat as well? So if somebody wants to just drop a note to Maria, you can find her on LinkedIn. But I'm going to ask Heather if she would also just drop Maria's email right into the chat for you. And hang tight, because we have things for you. We've covered a lot. We've talked about flow down clauses, what they are, why you need them, and how to incorporate them. We included what the most important issues are you need to address in a federal subcontract. We talked about how to address one of the most common sources of conflict regarding disputes. And we include some tips on the best way to structure your disputes clauses. And so we have some questions for you. What one action do you commit to take, and by when? Because you were here. What did you learn? What are you going to do? Drop that in the chat, because Maria and I would love to know what light came on for you as a result. Now, we have things for you. And so hang tight. Again, I'm just going to ask Heather to drop some links in the chat for us as we go. So we're ready for links, Heather. Heather Herbine is my moderator and support. And we're going to get to questions. We got questions from Darla and a couple of others, and we are going to get to those in just a minute. So there are 4 keys that unlock your federal wins: to know what to do, what to say, and what to ask to the players at all the layers. Define and identify your specific target agencies, the people you're meant to serve. Have a methodical, systematic way to get in front of those buyers. And finally, use the plan. Those 4 things. You're going to do those things whether you and I work together or we never do. But those are the things. Master the federal sales game, focus, have a plan, use the plan. And that's what we do when we work with our clients. Resources then. Heather, ready to roll? All of our work is centers around being able to help you make the human connection that lets you get in front of buyers before the spec gets written for somebody else. This is what we call practicing the art of federal human connection. In real terms, what do I say to a contracting officer? What do I say to an end user? How do I have a conversation? How do I get them to return my call? Can I ask this question? How do I talk to someone before the solicitation drops? We practice these skills every month. And you are invited as part of my service to the community, part of my showing you what it means for marketing to be an active service. Is this marketing? Sure it is. It's a chance for us to get to know each other, for me to give you something of value, but for you to also have the experience of seeing what does it mean to offer something of value to somebody else on the way to building the relationship. You get to practice doing that. Register for Come Together. These sessions are something we host on the 2nd Wednesday of the month. 2 former federal acquisition professionals are here for you to ask your questions. Throw your question into the ring when you register. We're going to pick about 6, and you're going to do those live. It might be a role play, but it'll be simulating a real conversation that you want to have and you're not sure to have with a real contracting officer. That's what Come Together is all about. The next one is on March 10th. 15 magic minutes, how to optimize those industry outreach conversations. You're sitting in front of these people at an outreach or matchmaker. What do you say? Yes, you're going to get a copy. You're going to get a link to the recording, Kelly. And so we've got some other things for you. The 5 people you need to meet. Who are those people? What do you say to them? Our GovCon Personas Guide is free. 22 pages of goodness and ideas for what do you say? What do you ask? It is Awesome. Our next webinar is coming up in March as well. But your next win, if you're new, you can grab my book. The first chapter is free. It's an Amazon #1 bestseller, and the companion workbook just got published. So grab them off Amazon. In the chat, you're going to find the link. You can go get chapter 1 for free if you're sorting through, is federal contracting good for my business? And if so, what next? Those are all the goodies we have for you. They're all in the chat, and we're going to have those links as well. You're going to get a recording to this. It's part of your follow-up, and we're ready for Q&A. So with that, we've got a bunch of those now. And so let's see here. So Pamela says we'll be reviewing our current subcontractor agreements to make sure we cover the right provisions. Excellent. John's going to review our subcontracts for missing items. Let's see. Darla Sanchez is going to review the termination for convenience clause in our subcontract template. Darla's going to not just agree to sub without getting a contract in place with the prime. Excellent. Excellent. So we've got some other questions. Brian has a question about when are equitable adjustment claims usually filed? For example, a multi-award IDIQ, government puts out a requirement for an additional certification and then puts out a new bid task order.
So I think it depends. I think might be talking about two different things. So there are REAs, requests for equitable adjustments, and there are claims. Both are ways in which a contractor can seek compensation, either in terms of days or dollars. So, or another way of phrasing it is to seek to adjust the contract, either in terms of days or dollars, for issues that have come up during performance. So that's usually where, if you're performing and the government makes a change, like all of a sudden they say, hey, before you can go ahead with this, you've got to get this additional certification that we forgot to tell you, and it holds up the job, just by way of example. And that would cost you additional money in terms of, how long it took you and your overhead in the meantime, et cetera, et cetera. There's also bid protest issues, which are separate and apart from REAs and claims. And given the facts as you just recounted them, I'm not sure exactly what your factual circumstance is, but they're also, if it's in the solicitation phase and the government, drops a new requirement that you need to have an additional certification, that's probably more in the bid protest realm of things, where you'd be challenging or, seeing if you could challenge the need for that change, and whether or not that, hurts or helps your chances of getting the procurement or getting the award, I should say, ultimately. But if you have questions about that separately, I'm happy to talk to you about it offline. You can contact me directly.
Mm-hmm. Okay. Dawn Johnson has an interesting question. If Dawn is still here, I want to ask if she is. She's here. Dawn, you had a good question, and I'm wondering if I can ask you, are you still on live? Because I'd love to hear you talk a little bit about the situation you're in. Dawn Johnson, are you with us?
Hey, understand me? Hello.
Hello. Talk a little bit about the situation that you're in, about the teaming, and if and when after contract award the teaming agreement just dies, and how does that relate to the subcontracting agreement? What's your situation?
It's basically a question because it actually came up that I did sign a team agreement with the prime, but I hadn't seen the contract. It was really moving so fast. It was an RFP that they had to respond to and within 2 weeks. So my question is, unfortunately, nothing happened with that. But my question is, if it was have gone through, and I signed that teaming agreement, and you went over some interesting information, what happens with that teaming agreement? I haven't seen the contract. I don't know what should have been filled down to my company, so I would be at a disadvantage all around.
Maria, what's your thinking?
Yeah, I think the key is for those of you guys out there who don't know the term teaming agreement. Their teaming agreements are or I should say teaming relationships are a special type of subcontracting. So, subcontracts, you've got the prime contractor and they have a subcontract with a subcontractor, right? Teaming agreements is kind of a step before that. It's you sign a teaming agreement saying we're going to enter into a subcontract if we win this opportunity from the government. So rather than, usually the way it works is rather than, a prime contractor go through the competition, get the award, and then enter into a subcontract with a subcontractor, they say, hey, I think letting the government know that we're working together is going to help my chances of getting this award. So as part of my bid or my proposal or my quotation, as the case may be, I'm going to put together a teaming agreement and say, hey, just so you know, I'm working with this subcontractor. They're going to be a major part of my team. They're going to be a major subcontractor. They're going to be, subcontracting a decent portion of the work. And here's our teaming agreement that says that if you give me, the prime contractor, the contract, I'm going to enter into a subcontract. So it's a separate agreement. Teaming agreements are one thing. Subcontracts are another. Teaming agreements lead to subcontracts. And whether or not they're enforceable, and by that I mean whether or not the proposed subcontractor can enforce it and say, hey, you have to give me a subcontract because you got the contract. We said you were going to give me a subcontract if you got the prime contract, and you got it. You have to give me the subcontract now, is going to depend on how you wrote your teaming agreement and what state's law applies and how enforceable and airtight you made it. I generally, best practices is not to sign a teaming agreement unless, you've talked to an attorney and made sure that you've covered the basis in terms of exclusivity, enforceability, the other expectations relating to the contract. And a lot of times you kind of want to flesh out or sketch out at least what the subcontract would be. And obviously, depending on, what position you're coming from, you either want it to be enforceable or you might want some wiggle room there. And then, you want to know what terms in the subcontract you'll ultimately be agreeing to. So I think you got to be aware of the process, which is teaming agreement and then subcontract, or teaming agreement with future subcontract that's already been written attached as an exhibit. And you've got to be aware that, you've got to make it enforceable if you want to be able to enforce it. And then you got to be aware of the subcontract terms you're agreeing to. There's two separate agreements.
Wow. If this were easy, everybody would do it. Hey, we've got one more from Marie Chavez, who's talking about proper notice. She says, I'm going through design build and there are things on the final design that I didn't bid on. I'm waiting for my subcontractor to provide the cost. Do I mention it to my client or wait until I have a cost proposal modification? Does that give you enough information to answer, Maria?
Yes and no. I mean, it sounds like what you're talking about is that there's a potential change or a potential issue that arose during performance and it could result in additional costs. I think, whether or not you should be giving notice upstream right now depends on, how far into it you are and which clause this is relating to. If it's under the changes clause, if it's under the delay clause, what clauses are in your contract. I think the key is always to at least let the government know what's going on and then follow up with specifics later. But you're always going to want to trace that back to which clause in your contract is applicable to this situation and what does that say in terms of your notice requirements.
Marie-Lupe, does that help you a little bit? I've got you off mute. Okay. We are coming up on the last few minutes of our session. And I've got one more. Someone is asking what type of lawyer handles these federal contracts. Maria, if somebody's looking to find a qualified lawyer who understands federal contracting, how should they go about it? In addition to ask Maria, because she's here, if somebody more specifically.
Sure. Yeah. So there are government contract lawyers like me, and that's usually the terminology that's used: government contract and specifically federal government contract attorneys. And there are many of us, well, as compared to the general field of law, we're a smaller group. There's it's a niche practice. But that being said, there's a decent amount of us out there spread across the country, but concentrated on the Eastern Seaboard, in DC. But there's many of us out there. Look for a government contracts attorney, one that specifically has experience with federal government contracts, and look for one that says that they know how to do subcontracting work.
And if you should be working with your procurement technical assistance center. And oftentimes a lot of the things for business development, for the same reasons why Maria and I are giving a free presentation here today, as part of business development, federal contracts attorneys who are in the neighborhood of your procurement technical assistance center will often collaborate and be presenters in your neighborhood. So you can also, first of all, start with Maria. One of the generosity should be rewarded. And so one of the reasons why people are generous with their time is also part of engaging and relationship development. So for goodness sake, start with Maria. If she's not a fit for you, she's probably going to be able to recommend someone who is. I've got 5 or 6 folks I work with regularly in your local town. Talk to your procurement technical assistance center and find out if, again, in your community, someone else has been donating their legal services and advice as part of support for the GovCon community. I invited Maria as my guest for not 1, not 2, but I think we're doing 3 of these together over the
Yep.
year, Maria. And this is in part in tribute to Maria's incredible generosity, as well as you can tell, her energy and her amazing expertise. So here, once again, is Maria's information. And Heather, if you would drop her email back into the chat one more time, so folks who want to get in touch with Maria can find her. And I would be delighted to work with you and your team. If your company is an established business in the federal arena, if you're looking to grow your federal business, if you're doing well as a subcontractor and are looking to grow as a prime, we may need to have it may be good to have a conversation. If you've just got a GSA schedule, you're not sure what to do with it. You don't have a GSA schedule and you're not sure whether or not you need one. You've just bought a company that has a GSA schedule and you're not sure how to drive business. I don't do GSA scheduled proposals. This is because I'm terrible at them and it's not my profession. If it is something that you need, I've got partners who do it. But if you've got a GSA schedule and you're concerned about whether or not you're going to meet your 2-year sales goals, these are things I help clients with. If you've got a freshly inked or early stage 8A certification and you're trying to figure out how to leverage that really powerful cert, some of my most successful clients are 8As. If you are in one agency doing really well and you want to expand, but you're not sure where, you want to make a good choice and move forward profitably and with focus, these are all questions that I work with clients on every day. And so let's stay in touch. You'll have another way to find out a little bit more. Book a call. We can explore if we're fit to work together. Our work centers around the art of federal human connection on the road to connecting you with the federal clients you're meant to serve, winning the work you've always wanted to win. That's it. So stay in touch. Be on the road with us to a life you love, in a business you love, supporting a country you love. Maria, thank you so much for joining us. Heather, thanks for putting all these great notices in the chat. Everyone here is going to get a link to the recording and all these juicy links again. Thank you again so very much. Let's stay in touch, be on this part of the journey in the federal arena together. Maria, thank you from the bottom of our hearts.
Thank you for hosting.
All right. See you all again.